This application is better done by a surveyor or an advocate. You can't do it on your own, but because you are very busy here in the Nation Center and you want to purchase this parcel of land, engage an advocate and ask for advice, first of all. Ask him for what he wants to do due diligence for you. An application is subsequently made after due diligence to the Land Control Board, which, as I've said, is supposed to be chaired by the Deputy County Commissioner. But a lot of times I see Deputy County Commissioners are delegating this to their assistants, who are senior assistant county commissioners. There would be a record, there would be a meeting, there would be deliberations, and then an actual consent is granted. And Janet, the consequences of not getting a consent from the Land Control Board for purposes of acquiring an agricultural land are dire. Number one, under the Land Control Act, you cannot get title. That title is going to be cancelled if there was no. It's an illegality. It's going to be cancelled. And then number two, you cannot recover the cost of your development because because you've made some good money. You've taken a loan, a huge loan from your SACCO. You want to very quickly put up a maisonette in this parcel of land in Isholo, an imposing structure, a structure that would excite every other person, all friends and foes across the county. The law says once your title is cancelled, you can only recover the purchase price. You cannot recover the cost of development. Okay. And that is why Kenyans now need to be witty. They do not need to just engage in the usual banter. They must go out of their way, engage a lawyer, engage a surveyor before they acquire a certificate of title in counties, in village. Land in this country is largely agricultural. If it's not agricultural, it's commercial. When you talk about agricultural, you're talking about parcels of land outside cities, outside towns. When you talk around small towns, there are a number of institutions, there are a number of offices that interact largely with land in this country. And it has several facets I would talk about for purposes of our discussion. It means, number one, you need to visit the land registrar with that title that you are supposed to acquire and conduct a search.
So I get the title from Janet.
Yes, you must get a copy of
showing
title.
that she's the owner of that land.
Correct.
Okay.
Armed with that title, you go to the Afisasa platform if you're in Nairobi. If you're in Kiambu, you go to the land registrar in Kiambu, because we are still digitizing in this country. We've digitized in Nairobi city. You are armed with this title. You go confront the land registrar. You can do it digitally for purposes of Nairobi. If you are in Kiambu, you have to visit the land registrar physically. You tell the land registrar, I want to know the ownership of this parcel of land. I want to look, in other words, at the register. If it is a lease, you would be given an extract of the register. And this extract of the register for purposes of a lease is what we call a white card. If it is a freehold, and a freehold means a parcel of land that you own forever until you are inherited by your heirs, you're given an extract of the title, and the extract of the title for purposes of this discussion is what we are calling a green card. So a white card is for a lease, a green card is for a freehold title. Okay. When you're given an extract of the white, when you're given an extract of the white card, when you're given an extract of the green card, it details to you who was the first owner of this parcel of land, who was the second owner, and who is the current owner. The first person to have been registered excitement. It also causes a lot of worry for us who are lawyers and who deal with conveyancing, who deal with real estate development, management, and financing, because ordinarily, under Section 26 of the Land Registration Act, and formerly Section 23 and 24 of the Registered Land Act, which has been repealed, and other provisions of the Registration of Titles Act again repealed, if you went to the land registrar and you were given what I've called a copy of the white card or a copy of the green card, that would have been sufficient due diligence. But today, as it is, historical search and this due diligence that you do at the lands does not end. This is something that you need to go to the very beginning, so that if this was originally 2,000 acres in the name of some cooperative society, perhaps Mboi Committee, or maybe Bahati Women, for example, it means you need to trace the original owner from the records of the land. So to answer your question, how far back you can go, from the decision of the Supreme Court in Dana management, it means you should go to the very, very beginning, the very title that gave birth to the subsequent subdivisions, to the subsequent subtitles, and ensure that every process, every step was legitimate, was done in accordance to the law. And this is very disturbing because we used to have a concept called the bona fide purchaser for value. You've seen notice of a parcel of land that is being sold. You've gone to the lands office. The lands office has told you this parcel of land belongs to Eric Latif. If the parcel of land belongs to Eric Latif and the law says that the certificate of title from the land registrar should be prima facie evidence, should on the face of it evidence ownership of this parcel of land. As an ordinary person in this country, what the land registrar gives you should be sufficient for you to move forward. And that is why we've put so much money into the Ministry of Lands. That is why we put so much money into Hathi House. That is why we have the National Land Commission, which is supposed to oversight the Ministry of Lands for purposes of public land. For the ordinary citizen, for the ordinary investor, what the land registrar gives you should be sufficient. But the Supreme Court, in its precedent-setting decision in Dana management, said that that is not sufficient. So that now, land as an investment is becoming increasingly shaky. Land in this country as an asset has been rendered onto vapor. I mean, it now more looks like you are gambling by buying land in this country.
And would you say this has been especially over?
Article 40, Clause 6 of the Constitution of Kenya suggests that illegally acquired property is not protected by the law. There is no right in land which you illegally acquired. But if you're an innocent purchaser, you've conducted your due diligence, you've gone down there to Kianjokoma in Embu and you've interacted with the village drunkard, you've spoken to the village manager, and he's confirmed that this parcel of land actually belongs to Linturi. This parcel of land belongs to Nyaga. And you've gone through the lands offices, you've gone through the local authorities, you've gone to the deputy county commissioner who's confirmed that at some point there was a conversion or there was some subdivision. Under the law, section 26 says where you are not part of the irregularity, you are not part of the illegality, you are not part of the mistake, then the lands office, the land registrar's green card or white card confirms prima facie that this parcel of land is in existence and it's genuine, and therefore you are entitled to compensation from the government of Kenya. That is where you are not part of any wrongdoing, you are entitled to compensation. But if you are part of fraud, if you are part of the illegality, then you may not be entitled to compensation because of Article 40, Clause 6 of the Constitution of Kenya. And as I said earlier on, Kenyans do their part. The investors that we have in this country do their part. The problem is that we have land officers in this country who are rogue. We have in this country land administrators who are rogue. They prepare a register for Eric Latif for the same parcel of land. You have Janet as another register for a parcel of land, similar parcel of land. Kipkoech as a title deed for the same parcel of land with a register. Where, I mean, how do you establish this? This can only be a product of fraud. And then when things blow up, when things get hotter, what happens? The lands officer decides to hide two correspondence files depending on who is the highest bidder. If Janet is able to bring in some tons of cash, the correspondence file belonging to Janet is guarded, is secured, and then Eric and Kipkoech, they sink. So we must push this conversation to the next level. Let the lands officers, let the land administrators who've issued genuine titles, who have opened correspondence files, who have issued certificates of leases, take responsibility. And not just take responsibility by ensuring that you are compensated. They should also be jailed. And the jail term for land fraudsters, people who interfere with the correspondence file, people who destroy registers, it should be a capital sentence, because country is not just valuable, it's also very emotive.
I can stand behind.
As of land, there is something called eternal vigilance. If you acquire land, the presumption is that you are going to occupy it, you are going to use it, and it's not going to be an idle land. And this tradition has found support in the Limitation of Actions Act, Chapter 22, Laws of Kenya, so that if somebody sat on your land for 12 years without your permission, and the sitting or the occupation of your land is not interrupted, then under the law of limitation, which is now settled law in this country, that person becomes the owner All he needs to do is to get a copy of your register, a copy of your title deed. He goes to the Environment and Land Court, and the court will declare that this person is now the new owner of this parcel of land, courtesy of what we call adverse possession. Adverse possession means courtesy of your absence and his presence in your land for a continuous period of 12 years.
Wakili, maybe I was not absent for.
It has to be documented. You have to do an agreement with this person and say, I'm now putting you into this parcel of land. You are going to be my caretaker because I am a busy person. I do not have time to come to Kajiado because, as you know, I reside in Lavington and I'm a very busy person at the Nation Media Group. So you're here, courtesy of my license, you have permission. There's an exception to the rule.
It has to be written.
Yes.
That makes sense.
I think that's written because the issue of a verbal agreement is neither here nor there. If this person disputes and there is no witness, then it can be taken that there was no permission, because if there is permission and permission is better demonstrated in writing, this person cannot claim adverse possession. It's very interesting, and I know several people have done several cases on adverse possession where somebody has walked away with several acres of land. I've had a group of people who've made away with 1,000 acres of land in Narok, courtesy of adverse possession, and I think there is merit in adverse possession in this country. Why would you want to have 2,000 acres of land? These parcels of land are idle.
Lying idle.
We have squatters in this country.